Welcome back, everyone, to OpenLine. We're taking your calls. We're talking about elder law. Several people on the phone here. Let's go to Sue Ellen. Chris Johnson there via Zoom. What is your question, Sue Ellen?
Okay. My question is this for the attorney. He's discussed about funding a trust and how if you just have a will instead of a trust, all this probate information becomes public record. Well, here's my scenario for the attorney. Say the trust has been funded and the person that is in the trust dies, and then after they're dead, one account shows up that was never put under the trust. Does all that probate information be made public? You know what I'm saying?
I know exactly what you're saying.
If you didn't have a will at all, is it now all public, or is it only public on this one account?
Sue Ellen, you asked the perfect question. This is going to be a great one because this is a question.
Is this something you would get asked in law school? Is Sue Ellen a law professor who has come on here and has asked an essay question? It sounds really smart. It sounds like a very smart question.
It's a very smart question because it's something that happens more often than you think, because the one thing about trust funding is exactly the way Sue Ellen is laying it out. The trust is going to control the assets that you get into it. And so deeding the home in the trust, beneficiary designating or retitling accounts into the trust controls only what you put in it. I kind of refer to it as an empty bucket. You need to fill up that bucket. And so Sue Ellen's talking about what happens if we find this one account that we forgot. You'd be stunned how often this happens. It's actually more regular than you think, despite, in our firm, we do asset spreadsheets. We go line by line with every asset of the client and give very detailed instructions. Here's how you need to title this asset or beneficiary designate. We do the deed work here in the office, but you have this one asset, and so we would call that a probatable asset. We have a non-probate or a probate avoidance plan with a revocable trust, but this one little asset's hanging out here. So anyone who does a revocable living trust, if they do it right, they're still going to do a will. And it's a special kind of will, and it's going to be called a pour-over will. And what that pour-over will does is exactly what it sounds. For that one asset that misses it, you're going to still petition, depending on the value. You're going to petition to open probate. Maybe if it's a low enough value, you can do a small estate. If it's truly a tiny amount, $5,000 or less, you can actually write the financial institution what's called a TCA letter and ask them just, hey, can you transfer this money? Because the banks have some discretion depending on the amount. But let's say it's a full probate, you're going to open probate. But two things, when you list the heirs in the will, the only heir from the will is going to be the revocable living trust. And that's what that will is designed to do, is catch that one asset and pour it over, hence the term pour over will, into the trust. So the trust will still control everything. It just thinks that you had to go to probate. The other thing is you don't have to list the value of the entire estate. You only list the value of the probate estate. So let's say that one account is $70,000. You're going to probate $70,000. That trust could have $7 million in it, but the probate estate is only going to be the $70,000 or $80,000 or $10,000, whatever it is, that one account that missed it. And so the analogy I always use is it's like baseball. The catcher is your trust, and the pitcher is the grantor, the person funding the trust. Every one of those baseballs is here's the deed, here's the checking account, here's the savings account. And what happens is if a ball gets past the catcher, the trust, that pour over will is the backstop, and it catches it, and it makes sure that the catcher can go back and get that one asset. But what you're going to do is, we talked about the kind of the scammers and the bad apples that are out there. The probate for that one asset will still be a public record, but you have two things working for you. One, people aren't seeing the full value of the estate. They're seeing a very tiny amount, and it might not be worth their time for that one asset to try and do something wrong. And two, they're going to see the heir as a trust, which means the probability that it is being managed much more meticulously because it's being managed for third parties and there's fiduciary obligations, the ability to scam the trust is going to be a lot lower than it is just, AJ off the street that just, hey, look at me, I just got a lot of money. So that's a fantastic question. One of the biggest things we emphasize with all of our clients is to get your trust funding done. Get those beneficiary designation forms done. It's a mild inconvenience because it takes a few hours of your time, but once it's done, and you avoid that exact scenario. And I want them to avoid it because when you have a probate avoidance plan, you shouldn't have to go to probate.
Well, thank you. Okay, that's great. Sue Ellen, good question. So Sue Ellen comes up with a great question, and that's basically our time. We will come back, and I'll put up the numbers for Takacs McGinnis and how to get in touch with the office. But Chris, thank you so much for coming on.
Thank you so much, Ben. It's a wonderful time.
You bet. All right, we will take a break, come back, wrap everything up right after this.